A law that was signed in 1965 to protect the right of every American to have their vote count just got dramatically weakened, at least according to many legal scholars and civil rights advocates. Not repealed, not thrown out entirely, something arguably more consequential, quietly hollowed out from the inside. On April 29, 2026, the United States Supreme Court handed down what some voting rights organizations are calling one of the most significant decisions for American elections in over a decade. A ruling decided along ideological lines that civil rights groups say represents a historic turning point. And the reality is, most people have no idea this even happened. So today, we are breaking it down. No fluff, just the facts, what they mean, and what comes next. Stay with me. This one matters. Before we dive in, real quick, if you are new here, welcome. This channel exists for one reason: to take complicated topics, law, politics, history, and explain them in plain language so you can form your own informed opinion. No yelling, no theatrics, just clarity. If that is something you value, hit subscribe right now. It is free, it takes 2 seconds, and you will never miss a breakdown like this one. One more thing, drop a comment below right now. Just one word: rights. It tells me you watched all the way through, and it helps this video reach people who actually want this kind of content. To understand what just happened, you need to understand what the Voting Rights Act actually is. It is 1965. The civil rights movement is at its peak. Across the American South, legal barriers, literacy tests, intimidation, and other systematic obstacles were preventing Black Americans from casting ballots, despite the Constitution guaranteeing them that right. President Lyndon B. Johnson signed the Voting Rights Act into law on August 6, 1965. At its core was a provision called Section 2, a federal rule stating that no state can use any voting rule or procedure that discriminates on the basis of race, color, or language minority status. For 60 years, Section 2 was the legal tool that minority voters could use in court when they believed their voting power was being deliberately diluted, particularly through a tactic called gerrymandering. Gerrymandering, for anyone who needs a quick explanation, is when politicians draw the boundaries of voting districts in a way that advantages one group over another. You take a community, you slice it up or pack it into one concentrated area, and mathematically, their votes carry less weight. Section 2 was the primary legal shield against that happening to minority communities. Was, past tense, because that is where this story gets complicated. The case is called Louisiana versus Callais, and it started with a map. In 2022, Louisiana redrew its congressional districts. At that time, Black residents made up roughly 1/3 of the state's total population, the second highest percentage of any state in the country. But the new map created only one majority Black congressional district out of 6 total. Civil rights organizations and Black voters sued. They argued this was a violation of Section 2, that the map was systematically diluting Black voting power. A federal court agreed. They found the 2022 map likely violated Section 2 and ordered a revised map, which Louisiana drew in January 2024 during a special legislative session. Then, a group of white Louisiana voters, the lead plaintiff was Philip Callais, sued again. They argued the opposite, that the newly drawn district was an unconstitutional racial gerrymander, that race had been used too heavily in drawing the lines. Here is the bind. On one side, a legal obligation to protect minority representation. On the other, a constitutional argument that race cannot be the dominant factor in drawing any district. The Supreme Court took the case, and on April 29, 2026, they ruled 6-3, decided along ideological lines, that Louisiana's second majority Black district was an unconstitutional racial gerrymander. The majority opinion was written by Justice Samuel Alito. That is the ruling. But the ruling itself is almost less important than what legal analysts say it may do to the law going forward. Stay with me, because the next section is the part most headlines are getting wrong. Section 2 still exists on paper, so why are legal scholars and civil rights organizations calling this one of the most significant setbacks for voting rights in over a decade? 3 reasons, and they matter. Reason 1. Critics say proving discrimination just got significantly harder. Under the legal framework established in a 1986 case called Thornburg versus Jingles, voters had a 3-part test to prove vote dilution under Section 2. Critically, the 1982 amendments to the Voting Rights Act had established a results-based standard. Plaintiffs needed to show discriminatory effect. Proving intentional discrimination was not required. Legal analysts reviewing the Callais majority opinion argue the ruling may function in practice much closer to an intent-based standard, one of the highest evidentiary bars in American law. The Center for American Progress writes that Justice Alito's opinion makes it, in their words, incredibly difficult for voters of color to bring VRA claims. Critics argue this represents not merely a shift in emphasis, but a fundamental change in how Section 2 may function in redistricting challenges going forward. The court, for its part, maintains it is upholding the statute as written.
Reason 2. Partisan framing may now provide legal cover. The ruling has led civil rights advocates to raise a concern. If a state can argue its district lines were drawn for partisan political reasons, even if the practical effect on minority voters is similar to racial discrimination, that framing may now carry significant legal weight. In plain terms, the outcome for minority voters can look similar, but if a state frames its decisions as politics rather than race, the legal exposure may be different. Civil rights organizations describe this as a significant gap in what remains of Section 2 protections. The majority argues this reflects the constitutional limits on race-conscious line drawing. Reason 3. The ripple effects are already underway. According to reporting from Democracy Docket and the Brennan Center, lawmakers and political strategists in multiple states are already examining whether this ruling affects redistricting options ahead of the 2026 congressional elections. Additionally, the Supreme Court issued a separate unsigned order, sending cases involving state legislative maps in Mississippi and North Dakota back to lower courts, directing those courts to reconsider their decisions in light of the Callais ruling. That order is confirmed and sourced. Exactly how far lower courts apply this ruling in those cases and others remains uncertain, and that uncertainty is part of why this decision has generated such intense legal debate. The map is already being redrawn. To understand the full weight of this moment, you have to see it as part of a pattern. The Supreme Court's decision in Shelby County versus Holder ended the operation of Section 5 of the Voting Rights Act, the provision that required states with a documented history of discrimination to get federal approval before changing their voting laws. The Brnovich decision. The court significantly raised the bar for challenging voting rules that make it harder for certain communities to cast a ballot under Section 2. Callais. Critics argue it has functionally narrowed the standard under which Section 2 redistricting challenges can succeed, moving what had been a results-based framework towards something legal analysts say operates in practice much closer to an intent requirement. 3 decisions, 13 years. And the legal tools available to challenge discriminatory redistricting have, according to civil rights advocates, narrowed substantially at each step. In her dissent, Justice Elena Kagan wrote, and I am quoting directly from the ruling itself, that today's decision renders Section 2 all but a dead letter for redistricting claims. Now, reasonable, thoughtful people disagree about whether this is the correct legal outcome. The majority argues they are applying the Constitution faithfully, that treating voters differently based on race, even with protective intentions, creates its own constitutional problems, and that these policy decisions belong with elected legislators, not courts. Critics argue the opposite,
that without enforceable legal tools to challenge maps that dilute minority votes, the right itself becomes unenforceable in practice. A right that cannot be defended in court is, in practice, a promise with no mechanism behind it. This is a genuine, serious legal debate, and it is now moving, at least partly, from the courts back to Congress. So where does this leave things, and what, if anything, comes next? That is where we are going right now. Section 2 still exists. Congress still has the authority to strengthen it through legislation, though whether there is political will to act is an entirely separate conversation. Civil rights organizations are already beginning to plan legal counter-strategies. Some are focused on state-level protections. Others are pushing for congressional action. Legal challenges to redistricting maps drawn in the wake of this decision are beginning to move through lower courts, though many cases are in early stages and details continue to develop rapidly. The Supreme Court has issued a separate, unsigned order directing lower courts to reconsider the Mississippi and North Dakota state legislative map cases in light of Callais, confirmed by SCOTUS blog and NPR reporting from May 2026. How those courts ultimately apply the ruling remains an open and actively contested legal question. This story is not over. In many ways, it is just beginning. Here is something concrete worth understanding before you leave. The 2026 midterm elections are months away. According to reporting from Democracy Docket, some state legislatures are already reviewing maps that could affect majority-minority districts ahead of those elections. The congressional map that voters walk into a polling place with this November, in some states, could look different because of what 9 justices decided in April. That is not opinion. That is a documented, developing fact.
The rules of the legal fight have changed. What happens next depends partly on courts, partly on Congress, and partly on how much attention the public pays to it. This channel will be covering those developments as they happen, state by state, case by case. If you are not subscribed yet, do it now, so you do not miss the state-by-state breakdowns as they develop. And if this breakdown was useful, share it. Not for me, for someone in your life who needs to understand what is actually happening. The rules have changed. Most people just do not know it yet. Now you do. Stay informed, stay sharp. See you in the next one.